To Investor-State Arbitration, hosted by the Chartered Institute of Arbitrators Nigerian branch. My name is Adenike Eson, a fellow of the Chartered Institute, and I'm glad to welcome you and to have you here with us. Whether you are brand new to the topic or looking to refresh your understanding of investor-state arbitration, this is the place for you. This session is designed to enable you to have clear and practical understanding, an introduction to the much debated area of international investment law. As we all know, investor-state arbitration sits at intersection of law, economics, and global politics. In simple terms, it's arbitration between foreign investors and host states. And to help us unpack the issues, the salient issues that will enable you to demystify what investor-state arbitration, I have a lineup of two erudite experts, professors, and I would like to first introduce Professor Emilia Oyema, who is here with us. Professor Oyema, she is a professor of law at SOAS University of London, and she is also the director of the Arbitration and Dispute Resolution Center. She's a fellow of the Chartered Institute and has experience as presiding co- and sole arbitrator and maintains an active international arbitration practice. Professor Oyema, you are welcome to this session.
Thank you very much, Nike. Thank you.
All right, then. I'll also be introducing Professor Paul Idonige. He's a senior advocate of Nigeria. He's a fellow of the Institute of Advanced Legal Studies, Abuja, a fellow of the Chartered Institute, and also a chartered arbitrator in notary public, a professor, and he's a member of several professional bodies, including the Permanent Court of Arbitration at The Hague, the Netherlands. Is a Chartered Institute arbitrator is also a member of the London Court of International Arbitration, African Arbitration Association, and right now he is presently a professor of commercial law at Veritas University, Abuja. And you are welcome, Professor Idonige, the learned silk.
Thank you, Nick. Welcome to everybody. Emilia, how are you?
I'm very good, thank you.
It's an honor for me to be moderating a session where I have two professors now. So for this session, I'm going to be calling on Professor Emilia as professor. I'm going to be calling her professor while I will call Professor Idonige Leonard Silk, so that when I'm directing my questions, I can know who exactly I'm trying to call. Again, welcome everybody. Wherever you are joining us from, please let's know where you are joining us from. Put it in the chat box, whether you are joining from Lagos, from Kaduna, Abuja, outside the country. It's good. Let's know where you are joining us from. You are welcome. And whether you know about investor-state arbitration or whether it's something that is entirely new to you, I can assure you that you will go away today with added knowledge, because of the experts that we have in the room. So we don't have a lot of time. And when introduction to investor-state arbitration, it could take, it's a thesis on its own. It's a PhD, it's in fact a research project on its own. So we'll try as much as possible to touch on those key areas that will give you some form of informed knowledge of what it is, why we are here, why it came about, where it is going, what has happened, the controversies surrounding it. That is one of the things we'll try as much as possible to achieve today. So without much ado, I would like to direct my first question to Professor Emilia. Investor-state arbitration, which sounds a bit technical, but it's just a way for foreign investors, to bring claims against, host countries. Could you break it down for us in very simple terms? What exactly is investor-state arbitration? Why this system has been created in the first place? What's so special about foreign investors that they deserve preferential treatment over national investors?
Nika, thank you so very much. And thank you everybody again for joining this webinar. Straight to the point, what is investor-state arbitration? It's what it says on the tin, investor-state arbitration. So it's an arbitration. We all know, you're all members of the Chartered Institute of Arbitrators. We all know that arbitration is a mechanism for the resolution of disputes. And so you appoint a third party neutral or neutrals, and they make the decision for you. And that decision is binding. And so that's exactly what we do in investor-state arbitration. The only difference when we compare it with commercial or civil arbitration is that it's between a state, so a sovereign, who is generally above the nationals. So it's between a sovereign and a national. Or usually what you would find is an individual or a company. And you can see that there is power imbalance. You have the sovereign, you have the state, and the question, the other angle to it is that the individual or company is a foreigner. And so if you think about it carefully, thinking about an alien, using the American expression, but for our purposes, the foreigner. The foreigner leaves their own jurisdiction where they are comfortable, where they know people, where they understand the legal system. And they are outgoing, they are outward looking. So they go out. And in going out, they go out taking their own resources in the form of assets, capital, technology, know-how, and they go into another country. It's obvious that the powers that the state wields, the state can wake up one day and say, leave my jurisdiction. What then happens to the property rights of that foreigner who has ventured out? And if you think about it carefully, you'd notice that that foreign investor needs additional protection. So that's where we are at now. How did we get here? Because it's, again, states are, if you like, international agents, and you then have a national. And just conceptualizing it under the basis of international law, we those of us who studied international public law in university would recognize that individuals are generally, at least before, were not subjects of international law. And now you are saying that an individual or a company, so a private entity, can sue a public sovereign. And that is a move away from what in the literature we'll call gunboat diplomacy. And gunboat diplomacy in the past was when the state, when its citizen has the property belonging to its citizen or the person of its citizen has been violated, the state can then can take on the rights of that citizen and pursue the offending state. The idea being, if you don't remedy my citizen, we will bomb you out of the face of the earth, effectively. And we had those bombings happening. You can imagine that would lead to wars and instability, power grabbing. I don't know whether with the current place we are with international politics and geopolitics, whether we have actually moved away from that, or we're moving back to those. So to ensure that we don't have those sorts of triggers, global war triggers, if you like, then international law evolved. Let me say it evolved to allowing the foreign investor to basically pursue a claim. So the states themselves have said, when we do not comply with XYZ promises we have made, if you suffer loss, then you can sue us directly. And if you remember that when we come to thinking through the law of diplomatic, it's an extension really of the law of diplomatic protection. And when we think of immunities of the state, as you remember, you can't sue a sovereign except the sovereign has consented to you suing the sovereign. So basically, that's what where we are at. But that is one historical view. For us, who, if you just sort of think about it, during the time of colonialism, the foreigner, so if you are a member of the empire, so you are an English business, you took your English law with you when you go to the colonies. And so there was no need for that law to protect the assets of the alien, because the law of the alien then was the one that governed the property rights of the alien. And so it wasn't necessary. And so looking at it from that southern perspective and looking at it from that angle, it became necessary after colonialism, when the new states became independent, that the former empires were quite concerned about what would then happen with the assets of their nationals in those colonies. And so that also gave impetus to the need to protect the property rights of a covered investor. I'm stressing this because that's really what the law of international investment is all about, is the protection of the right, of the property rights of the foreign investor. Sorry, Nike. Thank you.
Okay. All right. So thank you very much, Prof. From all that you have said, what I can say is that, the systems developed as a function of the need to protect the investment of foreign nationals in the host state. And it's not something that it's new. It started even before, from the days of gunboat diplomacy. But it has evolved to investment state arbitration. Now, I would like to ask, because now it is deemed as a pull factor, something to attract foreign direct investors, to give them some form of assurance that their investments are protected to some extent. What's the legal instrument? And this question is directed, at the Leonard Silk. What's the legal instrument that enables a foreign investor who ordinarily is not a subject of public and national law to, initiate an arbitration against a sovereign? Particularly, I've heard of the concept of, arbitration without privity. Can you unpack it for us? Leonard Silk, please.
Thank you very much, Nike. Good morning to all participants. It's nice to have this large number of people showing interest in this subject matter. Yes, for those who are used to arbitration, as explained by Emilia, arbitration is a consensual process. In other words, the parties must agree to arbitrate. And who are parties? Who are parties? If you look at Section 91 sub 1 of the Arbitration and Mediation Act, it provides that a party is a party to the agreement or those claiming through or under a party. However, investor-state arbitration presents its own unique feature. Hence, its description as arbitration without privity. There was an article written by Jan Paulsen in 1995. You can Google it. The title of the article is Arbitration Without Privity. So I'll talk about privity and the principle of attribution. Emilia has explained that under customary international law, investors had no direct access to the courts. Now, in international investment law, three legal frameworks profoundly affect arbitration. They are: one, treaties; two, statutes; three, contract. I will start with treaties. And I would like to start with the 1965 Convention on the Settlement of Investment Disputes between states and nationals of other states. I'll tell that again. Settlement of investment dispute, not between state and state, but between states and nationals of other states. Other than this convention, there's also the Energy Charter Treaty and United States Mexico Canada Agreement that used to be called NAFTA. What have they done? What have they done? So you hear terms like ICSID. ICSID means International Center for the Settlement of Investment Disputes. ICSID was established under this convention. If you look at Article 25 of the convention, it provides that the jurisdiction of the convention shall extend to legal disputes arising directly out of an investment. Legal disputes arising directly out of an investment between a state and nationals of other states. Now, this can include constituent divisions of a state that has been so designated and the center is informed, where the parties agree to submit to arbitration, In other words, under Section 25 of the ICSID, I will call it ICSID Convention, or I can call it Convention or ICSID Convention. Nationals of contracting states or the constituents of contracting states can invoke ICSID arbitration. Now, that Article 25 also defined who are nationals, but did not define investment. You find the definitions of both national and investment in the bilateral investment treaty. Now, so what this convention did was to empower nationals of other contracting states to proceed against the home state what they could not do under customary international law. To develop this further, we'll look at the Nigerian Netherlands BIT. If you look at any BIT, a BIT has two main parts. The substantive part that provides this protection of fair and equitable treatment, full security and protection, national treatment, most favored nation treatment, and the elephant in the room, expropriation. So you find all this protection in the substantive provisions of the BIT. Then, when you go to the procedural, that deals with how disputes are resolved. In the procedural, you have a dispute resolution clause. Now, in conventional BITs, a dispute resolution clause is like a cafeteria. You know, if you go to the cafeteria, you can eat rice, you can eat pounded yam with egusi soup, pounded yam with okra soup, pounded yam with tofu nubo. Now, so these clauses will provide for resolving disputes using national court, municipal arbitration laws, regional arbitration rules, ICSID, London Court of Arbitration, International Chamber of Commerce arbitration rules, or any other rule. I'll quickly say here, despite the cafeteria style, or like what we do if we go to parties where you can order for rice as first course and per diem as main course, there's what we call fork in the road. Fork in the road. What that simply means is, if you decide to eat rice, you will not eat per diem. And therefore, if an investor opts to go to the national court, is precluded from adopting any other forum. So these two main parts, substantive and procedural, if we have time in the course of this webinar, we will discuss the reforms that are going on now in this area. So if you look at Article 9 of the Nigeria-Morocco BIT, that is unique. Article 9 only provides for ICSID arbitration. And if you look at the Nigeria-China BIT, Article 9.2, or Nigeria-Morocco BIT, Article 27, you find that they provide for arbitration using this cafeteria style. Let me leave that and go to the second mode, that is by statute. Here, I will refer to the NIPC Act. The NIPC Act, if you look at Section 26 of that Act, it provides for dispute resolution. It draws the line between a Nigerian and a foreigner. So when any government of Nigeria has a dispute connected with investment in Nigeria, they can go to arbitration using our Arbitration Act. But in the case of a foreigner, they can use any bilateral or multilateral investment treaty. There's a case I'll quickly refer to in this regard. It's called Interocean and Nigeria. That arbitration was initiated under both the ICSID and Section 26 of the NIPC Act. When the claimant filed the process, Nigeria filed several preliminary objections. One of them was that Nigeria did not consent to arbitrate with the claimant. And for those of us who are vast in this area, you know that there's enough literature on where a state has a provision similar to the 26 of the NIPC Act. That provision is referred to as a standing offer. There's the case of SPP and Egypt, that when you have a contract that has such a provision, is a standing offer that an investor can accept. So the tribunal turned down the...
Leonard Silk, I may have to stop you for a while so that I can break it down a bit and do some recap for our participants.
Okay. Just to add that, other than this statute, contracts, like I said, there are three main instruments: treaties, statute, and contract. I'll stop here for now.
All right, thank you so much, Leonard Silk. Okay, before I do a recap of what the Leonard Silk has just, told us, I would like to thank, I can see that we have different people joining from different parts of Nigeria and the world. Faintola is joined. Thank you, Faintola, for joining from Ilorin. Nelly Kosi, you joined from Calgary, Canada. David from Uyo, Jacob from Ibadan, George from Sokoto. We have Anya Metu from Port Harcourt, from different parts of the world. I say thank you so much for joining. And somebody else joined from London, Mrs. Anuli from Onitsha. Thank you. It's going to be worth your while. So by way of recap, what we have heard is that private investors, foreign investors, can initiate investment arbitration, investor-state arbitration against the host state, that is where they have situated their domiciled, their investment. And they can do this on the basis of three legal instruments. If there's an existing BIT or MIT, that is multilateral investment treaty, or a trade agreement with investment protections, or if there is a national law, like the NIPC Act, that actually grants foreign investors access to international arbitration, investment arbitration, or there is an investment contract. So if foreign investors have these three, there's a possibility if, like, Professor Emilia has said, if certain standards of protections are, should I say, breached, there's a violation. And one thing I have heard from what Professor Emilia and even both the learned Silk has said is that investor state arbitration is quite unique. It's a different form of arbitration. Would you really say it is arbitration, considering the concept of advance offer of arbitration, consent that has no privity? At the time the host state is, giving its consent to arbitration, the investor perhaps might not even be in the country at that time. So what is the key fundamental differences? And I'm going to be asking Professor Emilia, between commercial arbitration and investment arbitration, just a few fundamental differences and perhaps similarities. Thank you.
Thank you very much, Nike. Investor state arbitration is arbitration. It's really important. It is arbitration. So the basics of arbitration is, again, a third party that makes a decision for the parties. You consider the law. On the basis of the law and facts, you make a decision that is binding on the parties, which would then be open to enforcement, to recognition, enforcement, annulment, and all of that. So it is arbitration. On whether it is consensual arbitration, as Prof says, it is consensual arbitration. So don't forget that you have what we call unilateral contracts and bilateral contracts. And so just because both sides have not signed a contract, as you would find in concession contracts that Prof was talking about, so state-based and investor contracts, where you have your contract and you have your arbitration clause in that contract that both sides sign. That is bilateral. But unilateral is what you get in investment treaties. The state itself has promised that I will arbitrate a dispute arising out of this if I breach this treaty. So there is consent, there's clear consent. The only difference, in my view, is that the basis on which you can challenge the actions of the state is different. So it arises out of regulatory breaches, which means the state would have done something or refrained from doing something that the state itself had promised in the treaty. That's the first one. The second one is that the investor is not party to that treaty. Remember that a bilateral investment treaty is basically a contract between two states. That's all that it is. It is the two states promising each other that if I do X, Y, Z, or do not do A, B, C, and it impacts on your own citizens who have invested in my country, then your citizen can sue me. And that's why we have the concept of what we call a covered investor and covered investment. So the example that Nike mentioned about the possibility of, as an investor or a foreigner, being able to sue a state even before maybe an investment treaty has been signed, will only arise where under that investment treaty, the state promises the prior stage of the investment, pre-establishment, that you're also covered where the states where your investment is impacted, pre-establishment. And that would be things around, when you have to bid, you breach procurement laws and things like that. So for example, a state like Nigeria, where you know that most likely some government official may have done something that may impact on the procurement laws or something. You have no business promising protection before you receive the investment. It's not rocket science. The idea with contracts is that you promise what you know you can deliver. And so the difficulty we have with international investment law is the use of templates, as Prof has been talking about. Is this templates of you just copy and paste. You're copying and pasting without carefully looking. So for example, we all know that currently we don't have security in Nigeria. I'm going to be drawing an example because this is Chartered Institute of Arbitrators Nigerian branch event. Why would Nigeria promise full protection and security when you know that you can't deliver on that, and it is unqualified? So those are the sorts of issues that we're talking about. And sorry, Nike, just a quick one to say that things have so developed that there is knowledge. So we're not just copying and pasting. And I'll just do a quick shout out to Prof, who also participated in the drafting of Nigeria-Morocco BIT. And to the NIPC for their continuing to revise and review the draft, the model Nigeria BIT. And that's important because model BITs say, this is what we can comply with. This is the basis on which we're ready to negotiate. I think that's important.
Okay, okay. You talked about covered and uncovered investors and covered investments. Certainly, before a foreign investor can have access, or should I say, have its claims admitted, there will be some jurisdictional hurdles that the foreign investor will scale. So, on that note, I'm going to be asking the learned skill. Can you just touch on, very briefly, a few jurisdictional hurdles that foreign investors have to contend with, when they, initiate investment arbitration? Of course, host state will always want to resist.
Okay.
So I would expect there will be some hurdles they will throw their way, and for them to, try and get it off at the preliminary level.
Thank you, Nike. Like I said earlier, the Exit Convention has defined who is a national. So one hurdle that investor will cross first is to prove that he is a national of a contracted state. Now, the BITs has other definition. I said earlier, the BIT defines investment. Now, in the past, most BITs were not very clear on what is an investment. We all recall the P&ID issue. Now, that's what we now call the Salini test that gives us the characteristics of an investment. An investment must make a contribution. The investor must assume risk. The investor must contribute to the economic development of the country. So the question that will arise in the arbitration is whether an investor has made an investment. This came up in the Ogun State arbitration. It was a dispute between an investor and Ogun State, but under the principle of attribution, the federal government was sued. I mean, I remember when the presidential jets were seized in France, then people were asking, how can a contract enter into between Ogun State and investor? How can you hold the federal government liable? It's under the principle of attribution. If I have time, I will explain it. If I do not have time, look at the International Law Commission's articles on state responsibilities. I take it again. International Law Commission's article on state responsibility, that the conduct of organs of a state are attributable to the state. So the issue of whether there's an investment will arise. Now, for Is it arbitration? Was there any consent, like was raised in the case of Ether Ocean? Now, the protection given, who is a national? What is most favored nation treatment? What is full, fair and equitable principle? What is full security protection? And like I said, the big one, expropriation. I like this word. Is defined as direct expropriation or indirect expropriation. Now, sometimes referred to as a creeping expropriation. It is not the law that says cannot expropriate, but there are conditions under which it can expropriate.
Okay.
Another issue that will arise is whether a fork in the road protection applies. And above all, whether there's a breach of any of the protections offered by the state government. These are areas that the issue of jurisdiction will arise. Thank you.
Thank you very much. From Leonard Silk's submission, what I hear is that for foreign investors to actually gain full access, you can initiate, but then it could, you must scale certain hurdles. In the first place, you must be deemed a foreign investor. And what will determine whether you're a foreign investor or not will mostly be the BIT and your investment. Unfortunately, the ICSID convention does not define investment. So you also need to justify, scale that hurdles. And a couple of other, if you have complied with certain protocols as entrenched in the BIT or the national law or the contract that enables the foreign investors to initiate that proceedings. But let's come down to, should I say, the basics. And I've heard, the learned talk about full protection and security, fair and equitable treatment. Professor Oyema, please, can you just, in very simple terms, explain what those substantive protections, what they mean in real terms, so that, and perhaps those state actions or inactions that incur international liability for host states and will be deemed a violation of full protection and security, fair and equitable treatment, umbrella clause, and national treatment. If I were to ask you to to unpack all of them, I'm sure we'll be here till evening. So I'm just going to limit it to, should I say, the most, most invoked, the fair and equitable treatment, umbrella clause, full protection and security, and the big one, expropriation without compensation. What do they mean in real terms, and what are those state actions and inactions that have been deemed to be violations of this treaty standard, bearing in mind that textual language in treaties, cost a number of different interpretations? Thank you.
Thank you very much, Nike. And one of the tricks to passing exams is, as you know, Nike, is one question at a time. So when you conflate all the questions, we'll try and do as much as we can. And we do appreciate that, even though this is billed as an introductory, or rather it is an introductory session, there were so many questions Nike wanted us to cover. And we were trying to push her to say, let's sort of do fewer questions. But quickly, and what I would encourage is each of us, what we're doing is Nick and myself, we're putting links in the chat to, there's a lot of material available for free online on this topic because of its very nature. So that's the first thing to say. The second thing is the easiest way to understand how complex the area of the law is you can just take Nigeria, Morocco, BIT. You can open it now and just go through. Most of the treaties are really essentially quite similar. And what we've done is academically, we look at them as generational. So we have the initial phases where you would have, for example, the Nigeria, UK, BIT. and they were described differently as reciprocal friendship. Initially was friendship, navigation, and commerce, those sorts of things, treaties. But they were just a few pages. And we didn't have many cases prior to the 1970s. So if you can easily see the exit statistics. And it was only when arbitrators started engaging with what exactly do we mean by fair and equitable treatment? What does it, when we say national treatment, most favored nation treatment, full protection and security, no discrimination, no expropriation, what does that mean? And it's a living area of the law. And this goes back to why it is arbitration. Because there is no precedence, yes, because we do not yet, at least for now, have a multilateral investment court. That is under discussion, but we don't have an international court that determines these questions. So you still get primarily ad hoc tribunals, 3 individuals that would say what they understand fair and equitable treatment to mean. We then moved on to where, because of transparency, we're able to see decisions or extracts where tribunals are beginning to explain this is the way we understand fair and equitable treatment, national treatment, most favored nation treatment, and all of that. And so that council can refer tribunals to those other decisions and interpretations. But there's no precedence. So tribunals are not bound by those earlier interpretations. A tribunal can still make their own interpretation. One of the things we're seeing is that tribunals keep pushing the boundary. So I have put in the chat a link to a decision against Nigeria, out of the facts that Prof was mentioning about the Ogun State and the Chinese company. And now they have an award against Nigeria anyway. And Nigeria is now trying to fight enforcement. And the money that Nigeria was trying to attach out of the judgment they got from P&ID versus Nigeria, the Chinese company would take that money, and it's not going to meet the award debt. But the key issue there that Nigeria was looking at was Nigeria was basically saying, we have immunity. You can't enforce without our consent or under Sovereign Immunities Act for the BVI. And the court then said that because in the treaty that Nigeria signed with China, Nigeria had said that they will enforce, that awards will be enforced. They agree that it will be enforced against them or against China. What the judge said effectively was that as far as he's concerned, what that means is that Nigeria had given consent for the award to be executed against Nigeria, so that Nigeria is not meant to be challenging that because they've already given consent. Now, any public international lawyer might find that really difficult to understand. Some commercial lawyers are finding it really hard because even the ICSID convention distinguishes between enforcement and execution. But what happens, the point I want to make is that whether it is a judge or whether it is an arbitrator, it's back to the way they interpret the promises that states have made. And so we're moving towards a third, fourth generation of treaties that are very detailed. And so we have standing joint committees that can interpret what states mean. Again, it's left to who you appoint, how the arbitrators deal with that. So, Nike, quickly, I know I had mentioned fair and equitable treatment. I have mentioned national treatment. I have also mentioned most favored nation treatment, full protection and security, expropriation. These are the primary, if you like, protections that states promise to investors of their counterparty. And so national treatment states basically, Nika, can I take 1 minute to just quickly explain?
1 minute.
Apologies that I went off track. So national treatment states basically promise that they will not treat a foreign investor less than they treat their own nationals. And then now we are beginning to have in like circumstances so that it's a little bit limited to that is in similar business and in similar situation. We then have most favored nation treatment. Basically, you're promising that the foreign investor will not be treated any less favorable than the investors from third-party states. So basically, you're saying all foreign investors, we're going to treat them in a very nice way. The most nebulous one is fair and equitable treatment.
Equitable treatment.
Which basically the state is saying we will treat the investor fairly and equitably. What does that mean? And so that is the one that almost anything falls under. And so where we are at now is that most modern treaties do not include a fair and equitable treatment standard because it means everything and nothing. A full protection and security, you're basically promising that the physical assets of the investor will be protected. And some decisions are moving towards things around even judicial. Judicial protection can also fall under fair and equitable treatment. Nika, does that
help? Thank you.
Apologies that
yes, it does. Like you said, a lot about, there's enough information, more than enough, publicly available on investor-state arbitration, investment arbitration. So please, check online. We've put some links there that would enable you. The Investment Policy Hub has a navigator for investor disputes. You can profile cases where investor states have claimed violations of different treaty standards and what the tribunals have held. So there's enough information about investor state arbitration publicly available. I would like to ask, and this question is directed, you've talked about attribution, and it's good that you have mentioned it to the extent that the actions and the inactions of different agencies and different levels of government can actually incur. And the Nigeria Ogun State, case kind of, emphasizes that fact. When different parastatals, agencies of government denying permits or do certain actions, it can incur international liability for the nation. That is, in simple terms, what attribution is about. And I was going to ask that question. But let's talk about, should I say, the elephant in the room, awards, the magnitudes of award. So, leaded silk, in the last couple of years, we've seen different sovereign states being having to contend with very high damages. Can you just touch on that a bit? Can you explain, how that has come about, what the reactions and the responses to all of these damages, particularly when you're looking at, when you're considering the fact that some of the actions that, were challenged in investment arbitration were actions that those nations had actually implemented for public interest, particularly maybe, to stabilize maybe the economy or to, get some windfall tax, so just touch on damages in investment.
Thank you, Nike.
Again, I have asked like 10 questions in one. So
I'll try and pass the exam. Right. Now, we are talking about expropriation. Like I said, No law says that you cannot expropriate, but when you expropriate, there are conditions. It must be for public interest. You must pay adequate, prompt, and effective compensation. You must not discriminate. And in pay compensation, you must pay a fair market value. The issue is, what is a fair market value? Now, for those of us who are used to computation of damages, you know that the most common method of calculating damages is discounted cash flow. Discounted cash flow. That is what was used in the P&ID arbitration to determine the present value of the investment that was to last for a period where the investor did nothing. Now, the BITs do not provide for other than expropriation. In the case of other breaches like fair and equitable treatment, the BIT does not provide for what should be the remedy. And so the tribunals have resorted to the customary law position of the principle of full reparation. Full reparation simply means that you should wipe out completely the consequences of the damage and put the injured party in the position the injured party would have been but for the damage. So, in interpreting all this, various tribunals have given various sums as damages. The most popular one is UCOS. UCOS versus Russia Federation. That is an arbitration that had 3 arbitrations. There were 3, and I don't know why the 3 were not consolidated, but the same tribunal heard the 3 of them and arrived at over $15 billion as the damages that are being awarded. In fact, there's one in the pipeline. It's called ZEF and Australia. The claim is over $200 billion. Now, these are some of the criticisms of investment arbitration. Why do you allow private individuals to superintend over a state affair, to preclude a state from regulating for public interest? And so ICSID arbitration has been one source where damages have been very, very high. But like I said, the highest has been, and that of UCOS was conducted under the Energy Charter Treaty that is peculiar to the energy sector. Before I conclude, I can see somebody asking here, talking about the enforcement mechanism of ICSID awards. Now, I'll quickly say here that the 1958 Convention on the Recognition and Enforcement of Foreign Arbitral Awards does not apply to ICSID award. 2, setting aside that you do in commercial arbitration do not apply to ICSID award. If you are dissatisfied with ICSID award, you apply for annulment. And in terms of enforcement, the convention requires the state to designate a court in their state where enforcement should be carried out, and it's usually the highest court. So in Nigeria, we have the enforcement of ICSID Act that provides that the Supreme Court. So ICSID awards are enforced at Supreme Court in Nigeria, unlike commercial awards that you can start from the High Court through the Court of Appeal to the Supreme Court. So ICSID, again, is part of the uniqueness. Is self-contained. It's unlike commercial arbitration. Thank you, Nike.
Thank you so much. Okay, we are getting to the end of the discussions, and we'll be proceeding to the question and answer section of this. But before we do that, I have one more question for Professor Oyema. And quickly, can you, the legitimacy crisis that is currently besetting the ISDS, Investor State Administration System. Talk on it. Let us know why it has come to be. I can imagine, and states' reactions to it. I think our people want to know how are states reacting to high damages, Russia, Venezuela, Bolivia. What's the perception?
Okay, so let's step back. The UNCITRAL has been working on this for almost 6-7 years. Nike will put a link to the working group 3. Nike, please, UNCITRAL working group 3. So if you're interested, you have almost 1,000 documents there that you can read for your summer reading enjoyment to bring you quickly up to speed. But the key thing for us to really think about is what exactly is the problem. You remember the example I gave coming out of the BVI courts. Does it really matter whether it is the individual as an arbitrator or a judge that is called upon to interpret a piece of bilateral investment treaty against proven facts? No, they do exactly the same thing. And I have published a blog on this, that my personal view is that we're just chasing shadows and wasting time, because there's nothing wrong with the process. The procedure is not the problem. So Working Group 3 has come up with a very steep code of conduct for investment arbitrators, or adjudicators as they call them. We now have agreement almost, I think, with an advisory center, an investor advisory center. The EU is pushing multilateral investment court. How would that change your decision as an arbitrator or a judge if, for example, Nigeria has, so let's use Nigeria again, and there are Libyan cases on this. Nigeria promises full protection and security, and Boko Haram moves in and takes over your property in the northeastern part of Nigeria. Whether it is a judge or whether it is an arbitrator, you have failed what you promised. You promised, nobody put a gun to your head. You promised full protection and security. Well, you can't even protect yourself or your citizens. And so they take, let's say, one of these commercial farms, and you're sued. I mean, you're liable. And my view is that it is for states to go back and look at it and ask themselves, how are we even benefiting from all these things we're signing? What is it? What sector of our economy are we willing? Because there's a cost. There's a cost element to this. What sector of our economy are we wanting to attract investment and investors? What types of investments and what types of investors do we want? So that at least you're sure that you're getting benefit, and you define for yourself what type of benefit it is you want to get from that investment. Is it job creation? What is it? Exploitation of resources? What is it? How is that going to help your own citizens? So we've moved away from copy and pasting, Nike. It is again back to the state. You have to take ownership, you have to take responsibility, and you have to promise what it is at least you can comply with. So going back to that example that Prof gave, of Zonchan. It's in the chat, Zonchan. Why would Ogun State take the property of the foreign investor? Why would you do that? And so the key thing, the other problem we have is that a lot of government people don't seem to appreciate that with those powers come responsibilities. And so there's a link to the draft articles on state responsibility. The state is the first citizen, so the state should be law-abiding. You can't just wake up and take people's properties. You cannot do that. And there is international law will not allow you to do that and get away with it. So I do agree with Prof. Sorry, Nika, I do agree with Prof that states are concerned because of the magnitude of damages that states are being plummeled with. But the key thing is that investor-state arbitration, the purpose is not meant to replace the investment. The purpose of investment, and that's the Prof has referred to Salini versus Morocco, and we've put the link in the chat. The purpose of investment is to help and support the development of the state. That is the primary purpose of investment. No genuine investor is going into another state so that they become P&ID versus Nigeria. So you don't do anything and you suddenly get 6 billion. None. Nika.
Thank you very much. Thank you very much, Professor Emilia. Our time is far spent. The legitimacy crisis, and there's been responses. Whether it is born out of fact or not is debatable. Some say it's the system is pro-investor. It favors investors. But then if you look at the database on the investment policy hub, the settlement ISDS navigator, it's you find out that there are more cases that were decided in favor of states than investors. So, but there's this perception, perception of bias, inconsistency, high magnitude of.
Nika, I'm sorry to interrupt you, but any data can be interpreted the way you want it to be interpreted. So if you have 50 billion award against you, don't forget that the UCOS award is now 70-something billion.
Because
you
of
have that against you. It's irrelevant that 30% of cases are not settled. It's the value. When you look at it in terms of value, do you know how much 11 billion that P&ID was awarded, how much of our GDP that is? And that is just one case against Nigeria?
Well, that is why there's that legitimacy crisis, and that is why there are different, should I say, responses. And it is not only the UCOS case, the Russia in Venezuela, they had to contend with a number of significant awards, 8 billion, 1.8 billion from ConocoPhillips. So different states are responding. We don't have a lot of time. I'll just post in the chat some of the responses of states. So one of the things that I know that has happened is that there's been a recalibration in terms of the BITs. Modern BITs now kind of impose, substantive obligations on investors, which allows host states to actually file counterclaims, therefore clearing the asymmetry nature of what we know as investor states. So before we proceed to question and answer, I will just ask one more question for Professor Idonige, and I will ask Professor Emilia the last question too. And my last question to you, Professor Idonige, is as for in-house and government lawyers who are facing these issues for the first time. What's one practical piece of advice you do offer them if you are, having to deal with this? Like maybe you're working in a multinational and setting of your permits or, licenses are being withdrawn or being challenged. how would you, what's one practical advice for government officials having to deal with this for the first time?
Yes, thank you, Nike. I was once a general counsel at the Bureau of Public Enterprises. So I was faced with this issue. My first advice to both in-house counsel and government lawyers is, if you lack knowledge in this area, seek external support. We lawyers are very arrogant. We think we know everything. Now, as you can see from our deliberations, this is a very technical area. So if you lack knowledge, seek external support. Now, before you appoint a counsel, the fact that I'm a senior advocate should not be the only qualified factor. Get a senior advocate with subject matter expertise in that particular area. Then in appointing arbitrators, the same thing. Don't appoint me because I am a chartered arbitrator. Look for a chartered arbitrator with expertise in the area. What I found wrong with our contracting system in Nigeria, there's no coordination between contracts entered into by the federal government and contract entered into by the subnationals. I think from this Ogun State experience, there should be a way of monitoring. For instance, the AG Federal can say, look, no state should enter into an international contract without clearance with the Ministry of Justice. And there's a need to establish a joint committee. You will find that in the Nigeria-Morocco BIT, that there's provision for a joint committee. Now, as part of the reform of the ISDS, one of the reforms is that no more ISDS, but seek exhaustion of local remedies. If that fail, embark in state-to-state dispute settlement mechanism, no more ISDF. Then in negotiating a contract, for me, this is very important. Mind the obligations that you assume. In negotiating a contract, as a general counsel, don't allow your boss to go and negotiate a contract and come back and ask you to draft. When I was general counsel BPE, I led the teams that did the negotiation. So don't assume an obligation you cannot comply with. Now, one thing I also find with government, when you are served a notice of arbitration, don't see it as an ordinary letter and keep it aside. I was involved in the exit arbitration, this OPL 245. When Nigeria was served that notice of arbitration, we did not respond. We did not appoint an arbitrator. The exit center had to appoint an arbitrator for the federal government of Nigeria. And lastly,
thank you so much.
We must learn to monitor contracts that we have entered into. For me,
thank you very much.
Dispute prevention is better than dispute resolution. Thank you very much.
Thank you very much. I'm sorry, I had to stop you there. Professor Amelia, one last question. And, before we go to the question and answer, what pathway and tips would you share for those that want to get involved in investor state administration? And I think in the course of this session, you have mentioned it a number of times, but, for the sake of those that missed it, if you want to, get into this area of law, if you want to know about it, more about it, you want to practice this, what's your practical advice to those that are listening to us at this time?
So Nike, 1 second, a few minutes, which is that the first thing I would suggest is that do an LLM, because it's really technical. And for some people, they can get a good textbook. They can read it just to get their heads around what is going on. And it's an area of the law that is changing quite frequently.
Yes.
So I would suggest do an LLM focused on international investment law and arbitration, if you like. Do an LLM or get a very good, and then loads of textbooks out there, and just read it, just to get your head around it and see whether this is something that is of interest to you. I think that's the starting point. The other thing is it depends on, most people are lawyers on the call, and it depends on the law firm that you're working with if they do this type of work. It's not one of those areas wherein you can just stumble along and hope that you get it right. No, it's important. And if you're a good marketing person and you get a case on investment law and you have no clue, I would strongly urge that you find somebody who's an expert to work with you. And then you can learn, it's almost like a tutorial. You can learn with them as they work with you. But it's not one of those areas where you can just get on with it and hope that it works, simply because of what Prof has said around the costs, the sorts of damages that are awarded. We haven't even touched on the cost. Has anybody asked the Ministry of Justice in Nigeria that how much did it cost them to challenge P&ID versus Nigeria? Just how much that one cost to do? Has anybody bothered to ask that question? But there is a cost element.
Thank you very much. Thank you very much. And I want to especially thank Professor Emilia and Learned Silk for the wonderful insights they have shared. And we are grateful for you taking out time to share some of these experiences and your expertise. For all of those that are asking about the CPD and the attendance, how to get your points, the CIAB, Chartered Institute Secretariat, they have the attendance list. It's a recorded session, and the system will automatically record those that were in attendance with, the time that you signed on. So all of that will be dealt with offline. So be assured you will not miss out on your points. And then this is the time for question and answers. If you have questions, and please, indicate by raising up using the reaction buttons to indicate if you want to ask any question, or you could drop them in the chat box for us to pick it up from there. If you have any questions on anything that has been said, or if you need further clarification, this is the time. Before we do we have any hands up? Okay. What it means is that you have explained it all. The two professors have explained it all. We have demystified,
Nika, there are loads of questions and comments in the chat. And we have our own foremost female African arbitrator who does a lot of investment arbitration on the call, Mrs. Adekoya, and she's been quite active in the chat. So it might be, you might want her to.
So I will just go back up and try and get to a comment and read it while I was hoping that before I go back to the.
Or can you get her to speak? Can you?
Yes, Mrs. Adekoya, are you still on the call? Leonard Silk, Mrs. Adekoya, Senior Advocate of Nigeria, is still on the call.
Okay, she may have left.
Okay.
I think I also saw Mrs. Dorothy Ufort SAN earlier. Is she still here?
Okay.
Okay.
So
let's look at has raised his hand.
Okay. Yes, please. Please go ahead. Unmute yourself and ask your question.
Say, unmute yourself, please.
And ask the question.
I think the host has to unmute you or give you permission to unmute.
Ms. Adekoya, we are looking for you.
I couldn't unmute myself.
Okay.
So,
Yemi?
I have unmuted myself, but I don't know what it is you've said.
We can hear you. We can
hear you very well, perfectly.
Between yourself and Professor Emilia, you've covered the topic. So I'm not sure what again it is you want me to say. I've posted in the chat, and I'll post some textbooks that those of us who got into arbitration after we had graduated, when there were no arbitration courses, can also read. But as Professor Emilia said, if you have the opportunity to take a course, you may not need to do an LLM, but you do definitely need to understand the principles of international arbitration, international investment law, and private international law. So that's all I would say.
Okay, so thank you so much, Leonard Silk, for your contribution. So if you have questions, could you just put them in the chat? While we wait for further questions, I would say let's look at the polls. We had asked some questions. What is investor state arbitration? Have you ever heard of investor state arbitration? And of the 43 people that attempted it, 29 said, yes, I understand it fairly well. 29%, 32% said, yes, but I'm not clear on what it means. And 38% of the people that answered the poll said, no, this is my first time of hearing about it. And certainly it is not going to be your last time. We have posted a number of links that will enable you gain more practical understanding. But again, if you want to have in-depth understanding, you need to take an LLM. Who are the parties in ISDS? Do you know? And two companies, 2%, and a number of people, at least 82%, were able to answer that correctly, an investor and a state, yes. So that is the difference between commercial and investment arbitration, the parties. Commercial arbitration can be between two private parties, but investment arbitration must always be between a foreign investor and the host state. Types of dispute in ISDS, which sector? Oil and gas and extractive industry, 58%, and that's exactly what it is. If you look at the database and the statistics and the profiling, you'll find out that oil and gas and extractive industry attract most of the dispute in investor state arbitration. So I'm checking the chat to see if there's any question. Okay, so there's a King's Clovis Okereke has asked, I'm not sure it will be reasonable to interpret a state's promise or undertaking of protection by a state should go beyond the level of protection a state is able to provide for its citizens, whether natural or artificial. Now, it's not exactly a question, it's a comment, but basically I would like Professor Emilia to touch on it. So now there's a query, why should investors get any preferential, foreign investors, why should they get preferential treatment beyond national investors? Give, for instance, the Nigerian space. The law that's applicable to multinationals that are foreign investors is also the same that is applicable to national investors. But national investors do not have such leverage, international arbitration, investment arbitration. Why should, that's basically, that's a query of, or should I say, comment of Chris Glovis. Professor Emilia, please, can you talk to us about that?
That's what your state has decided to do. So your state has said that they would give those additional protections to the foreign investor that falls within a particular bilateral investment treaty or multilateral investment treaty. That's it. I think that's just a very simple, straightforward answer that I can give without going into details. I think Prof might want to add to that.
Yes, Emilia, is a bilateral investment treaty protecting the investors of the two countries. So the way we protect the foreign investors here, that is how Nigerian investors are protected in the territory of the contracting party. So it's not one-sided. It's just that now, if you look at the Nigerian Netherlands BIT, how many Nigerian investors have invested in the Netherlands? Look at all the BITs. How many Nigerian investors have invested in those countries that we sign the BITs with? Like I said, the BIT applied to nationals of either country, and nationals are either natural persons or legal persons. So it's not one way. Thank you.
Okay, thank you so much. I think I would like to just add a little to that conversation, to the extent that, from what Professor Miller said in the first place, how did it start? It started as a function of seeking to protect foreign investors so that you can attract them. You see, capital is scarce, according to a Zimbabwean anonymous writer. It's a coward. It only goes where it perceives little or no risk. But then we all know that political risk is something that is always accompanies good returns. So it's been used as a function, as a device, a political risk mitigation tool to attract foreign investors, to say, okay, if you invest in my country, you have these standards of protections. I will protect your investment. If I violate it, procedural protection, you can initiate international arbitration. So it's basically a tool to pull, the pull factor, to pull in foreign direct investment. But then the question is, and this is why there's this legitimacy crisis, to what extent has, this,
I'm sorry, Nike, but shouldn't we be challenging that?
Yes.
Shouldn't we be challenging that?
Yes, and that is basically what I was going to say, that in Brazil, they have never offered any BIT. And yet.
No, the key challenge is this.
Yes.
Why do you, as a state, need to do the bridal dance to say you're jumping from one country to the other, to say, come and invest. We want you to invest. We will do this, we will do that. We need to begin to ask those questions. Why? Think about it. If you don't have, there is no foreign investor that is a charity. If you don't have what that investor needs, whether it's human capital, whether it is resources, whatever it is, why would they come? Which means that there is something that you have that they want to, that they need. And that is really important, because if we recalibrate our brains and say, I don't need, the point is not how beautiful I am on the inside. The point is I have a good character. So come if you want to come. What I am saying is that I will respect your property. I will provide an enabling environment for you to thrive, because if you thrive, my citizens will thrive. And then we begin to move away and we focus our energies on creating an enabling environment for genuine investors. Shouldn't we be pushing back on some of these things?
Professor...
Nike, I would like to come in here. What I found with governments in Nigeria, either at the federal level or subnational level, we are very good at breaching contracts. We're also good at entry to them, maybe without preparation or having a team that has the expertise in the area. But we are very good at breaching contract. We still treat commercial transactions like government work. They are not government work. These are people who are in commerce. They are out to make money. Now, read Ocean, the ruling, the award, they're all available online now.
Okay.
Ocean.
I may have to just stop you. I mean, it's a never-ending conversation.
No. Just to add that the investors will notify you of a breach. You just behave because you are a government. You ignore them. I think you should engage as soon as you are notified of a breach. Engage the investor. Don't behave as because you are a government department, you cannot be dealt with in another forum. International law will not allow you. Thank you.
Okay, so I'm going to have to apologize to Mahmoud Jato. Unfortunately, we cannot take your questions. You can put them in the in the chat. We'll pick it up later. We can respond to you. Again, this is a never-ending conversation. You know, it's going on at different fora, and as to whether or not even all of the, should I say, the laudable, should I say, attributes, you know, of investment treaties, why different states entered into them, whether it has delivered for them the foreign direct investment. Like I was saying, Brazil has never offered BITs or MITs, and yet it has foreign investors. So, you know, there are so many reasons why perhaps there's this legitimacy crisis, and there's a rethink, particularly now that we have different international obligations, ESG, climate change, and sometimes they are poles apart. You know, when host states have to do they have certain commitment under international treaties too, other international treaties. And that is why there's a recalibration. The Nigeria-Morocco BIT in Nigeria is a modern BIT, the way to go from what everybody is saying nowadays. So we have come to the end of this session. Again, very interesting. We will continue offline. Professor Yema, Professor Idonige will continue offline. This is a session that you can continue on your own. Learn more about it. Read about it. It's publicly available. So many databases that you can leverage on to gain information. But then if you want in-depth knowledge, according to Professor Emilia, and I agree totally, do a master's in international investments, in international investment arbitration or dispute resolution, and you gain more understanding. It is not yet on its way out. Yes, it may seem as if because of different reactions to the legitimacy crisis, it would seem as if, oh, investment arbitration, it is not yet. Nigeria has had its own fair share of investment arbitration, with the first award against it the Interocean one, there was no award against Nigeria, fortunately. You know, and that was on the basis of the NIPC Act. But then it's an ongoing conversation. One thing I would like to stress is that it's not about contract. Sometimes the foreign investor may have no single contract with any agency of government or federal, state, or local government, and yet can still initiate investor state arbitration if there's an enabling BIT or MIT between the host state and the home country, home nation of the investor. Thank you so much, Professor Idonige. Thank you so much, Professor Emilia. I appreciate, the wealth of experience and expertise and insight you have shared. This is now afternoon. One more word of bye-bye. And I will call on the branch chair to give a vote of thanks. But one more word from Professor Idonige. One word to say.
And one word.
One word. One word.
Dispute prevention is better than dispute resolution. One word.
Thank you so much. When you are with professors that are used to lecturing, Professor Emilia, one word too, please.
I agree. Dispute prevention. If the treaty is not giving you what you want, you'd have no business signing those things.
All right. Thank you very much. And so over to the branch chair, Mrs. Olusola Adegbomire, CAR. Please, a vote of thanks. Thank you.
Thank you. Mine too will just be about a few words because we have really overshot our time. I think I have just a minute to say thank you so much to my sister Emilia and our daddy, Professor Idonige. Thank you so much. It's interesting that we have all these very senior people. They are our people and always ready to come in and to share so much of themselves and to bring in a new crop of people into this thing that is supposed to be like a cartel, but thank you so much. Yes, but, you don't hesitate to talk about it, to let people know how to get into it. You're not closing doors, shutting gates. Thank you very much. Of course, I'm glad Mrs. Adekoya has spoken. I was going to say thank you. I mean, we didn't even go and invite her, but I'm learning from people like that, that at every stage you need to keep learning. At every stage, attend webinars, attend conferences. There is always something to learn. Thank you very much to Mr. Adekoya for showing us such a great example. And there's so many seniors on this platform today. Thank you so very much. I can't start calling everybody. I see that there are people from America. Professor Laguju is attending from America and from all over the world. Thank you very much. There's so many lawyers here. I first thought when it went out as a CPD program that, oh, we'll have a lot of lawyers who just want to get CPD points. But I'm happy it's not so. I'm happy that many of them, because I've been reading the chat box, as I think Professor Emilia has, many of them are asking questions, they are interested, they are raising up debates, P&ID, and I want to thank all the lawyers who attended, because I see that we didn't just do it for CPD points. I can see you've done it for the interest. I can see that you've done it because you want to know more. And I hope that you have learned a lot. We'll have some more interesting programs like this, and we will let you know, and I hope you attend.
Well, I'm here too.
Aha.
Professor Dorothy, we've been calling you.
Yeah.
Professor, they thought you had left.
Yes,
Maybe he had been calling you to say what?
Oh, really? I did hear.
Yes.
But it's a very good program, and having done a lot of ICSID arbitrations, I think the knowledge shared is very good for the younger ones coming, for those who are already in it. I came to see if I would learn something new, and I've learned. You keep learning.
Hi, Sister Dorothy, happy to have you back in CIR, and I hope we'll see more of you.
Yes.
Okay.
Yes. Thank you
very much. Our next webinar next month, because this is a monthly webinar on specialist arbitration topics, the third Friday of every month at 11 a.m. Our webinar for the month of August is going to be on Islamic arbitration and Islamic finance. The topic is actually faith, finance, and there's a third F, but faith and finance at least. But it's going to be very interesting. Actually, one of the speakers also attended this program, Dr. Omar Oseni from the OIC Arbitration Center. He's here as well. And, so I'm happy that our webinars are being taken very seriously. So Dr. Omar will be one of our speakers next month on Islamic arbitration and Islamic finance. That's also going to be a great one, and we're all getting ready for it. I mean, there's so much I can say, but the time now is 12:32, and we should have stopped at 12:30. So thank you very much again, Professor Emilia, Professor Idonije. Thank you very much. And our moderator, she's also in that area, so that was why she was chipping in things. Thank you very, very much. And of course, the people in the background, thank you very much, Nelo, Professor Agbelusi. I've promoted Professor Agbelusi, Dr. Agbelusi. Thank you all very much. See you next month. And if you want to join the CIAB, please let us know. Just send us an email and we'll send you all the necessary information. The CPD points form has been put in the chat box, so fill your CPD points and get that 1 point. Thank you very much, and you all have a great weekend. Bye-bye.
Bye-bye.
Thank you very much, everybody, for joining us. Watch out for more of our programs. Thank you, and have a great afternoon. Thank you.